Department of Homeland Security, DHS, General Counsel James Percival has articulated the view that the public is entitled to awareness regarding the federal judges responsible for recurrent rulings that impede key aspects of the previous administration's immigration policies. He attributes this pattern largely to a limited number of district judges, whom he characterizes as acting in contradiction to the Supreme Court, and, in his assessment, exceeding the bounds of their Article III authority. Percival has taken steps to publicly identify these judges, while emphasizing that his primary intent is to inform citizens rather than exert pressure or intimidation on the judiciary. Percival maintains that the phenomenon is not endemic across the federal judiciary. Rather, he contends, it is primarily a consequence of specialized plaintiffs engaging in forum shopping to consistently present their cases before specific judges who, in his viewpoint, have demonstrated a continued willingness to intervene in immigration enforcement. He highlights a case involving Judge Brian Murphy, who issued an order limiting the removal of certain individuals, which necessitated Supreme Court intervention. Percival credits broad judicial consensus, including from justices across the ideological spectrum, with ultimately reaffirming the Supreme Court's authority in such matters. He stresses that his critique targets only a select group of judges whose repeated actions, according to him, may have implications for the perceived credibility of the judicial branch as a whole, particularly as most judges, in his words, continue to fulfill their obligations faithfully. He has also drawn attention to other district judges, such as Judge Matthew Kennelly and Judge Paula Zinnes, citing specific rulings that have paused removals or released individuals subject to removal orders. Percival frames these decisions as departures from established legal precedent or statutory interpretation, and labels such actions as judicial sabotage. He further contends that rulings from certain judges, in his view, unnecessarily constrain DHS operations and may distort public perception of the agency's activities. Percival compares his efforts to inform the public about these judges with similar DHS initiatives aimed at educating on immigration enforcement priorities. He asserts that transparency regarding judicial interventions is necessary to correct widespread narratives about DHS policies and operations. In response to critiques from media outlets and concerns about potential risks to judicial safety, Percival defends public, fact-based scrutiny of judicial decisions as intrinsic to a functioning democracy. He differentiates substantive criticism from personal attacks and invokes the principle of separation of powers, asserting the executive branch's prerogative to express disagreement with judicial interpretations. His remarks occur within a broader political context in which calls for accountability and transparency regarding judicial decision-making have emerged from both sides of the political spectrum. Recent incidents of public criticism directed at judges by elected officials and the accompanying national debate about judicial independence and safety underscore the sensitivity of such issues. Percival's stance situates itself within ongoing debates over the role of the judiciary in federal policymaking, executive authority in immigration matters, and the boundaries of public discourse concerning the courts. Throughout, he emphasizes his dedication to supporting DHS personnel and the agency's mission, while also highlighting the importance of safeguarding the integrity and accountability of all branches of government. Want to make sure you never miss our latest videos? Tap that follow button right now. If our content brought a smile to your face, made you think, or taught you something new, please like this video and share with your friends and family. Your support